Good morning, everyone, and thank you for joining us for our Senior Law Day program this lovely June day. We're here with a terrific attorney and longtime collaborative member, Fran Pantaleo, who's a partner at Bleakley, Platt, and Schmidt. And Fran is an elder law attorney who concentrates in both estate planning, guardianship for individuals with disabilities, as well as seniors. And she's here today to present on everything you need to know regarding special needs planning. So without further introduction, please give a warm welcome to Fran Pantaleo. And if you do have questions for her as she speaks and shows the slides, please enter them into the chat or the Q&A, and she would be happy to address them as the program progresses. So Fran, thank you very much for joining us this morning.
Thank you, Sarah and Bruce. It's really a pleasure to be speaking to you all today about special needs planning. And if you are a parent or a grandparent of a person with special needs, I don't need to tell you how many balls you have in the air and how much you juggle on a day-to-day basis. And there's so many decisions to be made. There's so much to do. It can sometimes be very overwhelming. So my job today is to try to make this process easier for you, to walk you through in bullet points the things that you need to think about as you plan for your loved one with disabilities. And for some of you, this is going to be very reassuring because you're going to hear everything that I have to say, and you're going to say, that's great, I've done all of that. And for other people, it may be, wow, now I have a roadmap. I have a list of things that I need to think about. And don't be overwhelmed. It's never too late to plan, or it can be too late to plan, but it's never too early. So hopefully you can, bit by bit, work on the things that you need to think about and get the plans in place to make sure that your loved one with special needs is going to be well provided for, both during your lifetime and hopefully also after your passing. So I'm going to bring up my screen. Okay, and hopefully now you'll see my PowerPoint. And we're going to talk about all the things that you need to think about. So what do we talk about when we talk, what do we mean when we talk about special needs planning? What we're thinking about are, special education and related services. I'm not going to talk about that today, but for a young person with disabilities, the first planning process is making sure that they get all the education and related services that they need. There are federal laws that guarantee an appropriate public education for children with disabilities and the right to an education up until the receipt of either a high school diploma or the child reaching the age of 21. And that's not part of my bailiwick, although I did that for many years. I'm going to concentrate more on what happens afterwards. So what happens after special education? There's life, right? And the school districts are required to assist with transition planning, and you need to start thinking, or you've already thought about, will your loved one be able to have a job? What kind of life skills will they need? What will their living arrangements be? And that's a process that starts around age 16 for children, and it continues, of course, throughout their lives. Once a child reaches 18, right, well, even younger, even minor children may be eligible for certain governmental assistance programs beyond what you get from the school system. But certainly after the age of 18, there's a number of government benefits that the person with disabilities may qualify, and I'll talk more about those. And then another question is, what if something happens to me? Is there going to be enough money to provide for my loved one with disabilities? How should their inheritance be handled? What should I leave them? Who's going to take care of it? And those are issues that we will discuss. And then lastly, is this person with disabilities, this person I love, going to be able to make their own personal decisions as life goes on? Will they be able to handle their money? Do I need to bring a guardianship proceeding for them? What kind of a guardianship? Or is this person needs some assistance, but have enough capacity that they can sign a power of attorney and healthcare proxy, HIPAA release, living will, and we'll talk a little bit about those as well. So that's the roadmap. That's what we're going to try to cover in the hour that I have with you. So government benefits. There's different types of government benefits that are provided to a person with disabilities. Some of these benefits are means tested, which means you can't qualify for them unless you meet strict financial eligibility requirements. And some of them are not means tested. They come, anybody can get them if they qualify for the program. So what are these benefits? The first is Supplemental Security Income, or SSI. This is a cash replacement program. It's an income program, like a welfare program for people who are age, blind, and disabled. But there are very strict financial eligibility rules. The person has to be qualified and certified to be disabled, right? Have a relatively severe disability, which prevents them from working and making a substantial income. But they also can't have too much money. The maximum amount of money that a person with disabilities can have and qualify for SSI is only $2,000. So it's really very, very little that the person can have. And they don't get too much from SSI either. We get cash that comes monthly. The maximum amount that a person with disabilities who lives alone can get in New York is $881. It's a federal benefit supplemented with a little bit of extra money from the state. And if the person with disabilities is living with other people and not providing their full freight of their own support, the amount of the check can be cut to about $450 a month. Other benefit that's very, very important for people with disabilities is Medicaid. Medicaid is a means tested benefit. You get it automatically if you're on SSI. You don't have to separately apply for it. But if you don't have SSI, you can apply for Medicaid, and you have to have assets, countable assets of less than $15,900. And if you get Medicaid, it provides a wide variety of services, and I'll talk a little bit more about that. But it's both health insurance and provides many additional services. There's housing assistance like Section 8, reduced, supplements to help pay for rent. Those are all those programs are income and asset based. They're means tested. There's SNAP, formerly known as food stamps. It's a cash payment to help with it's like a credit card that you can buy food with. That's means tested. And then there are the two very important benefits that are not means tested. One is Social Security disability income. That's a Social Security check that you can get if you are no longer able to work but used to work. If I became unable to work tomorrow, I could apply for Social Security disability benefits and get a check each month based on my work history. And it's completely unrelated to how much money I have. It's just related to how much I paid into the Social Security system. Now, what a lot of people don't realize is that when you work and you pay into the Social Security system, you're not only providing a potential benefit for yourself if you become disabled, but if you have a child who became disabled before the age of 22, that child can get a monthly check based on your work history if you either die, retire, or become disabled yourself. And so that's a very important benefit. Sometimes people are not aware that if their child went on SSI and proved their disability before the age of 22, and later the parent retires or dies, that the child is going to get a check, and it can be much higher than that maximum $881 that the child would get from SSI. The other very significant benefit that comes along with that is 24 months after the person with disability starts to receive Social Security disability benefits, a Medicare card is mailed to them automatically. And there are many doctors that take Medicare but do not take Medicaid. So that Medicare eligibility can be very, very important as well. I'm going to move ahead to the next slide and talk a little bit more about Medicaid. So Medicaid is the golden ticket, right? This is the most important benefit for most people with disabilities. Medicaid is required for child waiver services. Normally, parents' assets and income are counted in determining whether a child is eligible for Medicaid, but there are many programs available to provide assistance to severely disabled children in which the parents' assets and income are not counted, but the child can't have money. And those services are roughly grouped under the umbrella of child waivers. Also, if you have a person who has an intellectual disability, a developmental disability, they can qualify for services through a self-direction plan through the Office of Persons with Developmental Disabilities, OPWDD. And those waiver programs all require Medicaid eligibility. The services go far beyond what you might think of as a health insurance benefit. So I have clients with self-direction OPWDD services plans, and those service plans cover gym memberships, transportation training, someone to come into the house and help the person organize themselves, cleaning, life coaches. It is a wide variety of services that can be available through OPWDD waivers. The person has to have, again, a developmental disability, which manifests itself before the age of 22. But if they qualify, the services can be very extensive. Traumatic brain injury waivers is another type of Medicaid waiver service, can provide home modifications and many services beyond what one would usually think about for Medicaid. And then there are Office of Mental Health, OMH waivers. If the person with the disabilities may at some point need to live in a group home or in a supportive housing setting, they can only qualify for those services through OMH or OPWDD if they have Medicaid. So I have clients who are multimillionaires who have a lot of money, and we're very proud and would much prefer to pay for services for their children. But unfortunately, unless they get into one of these waiver programs, their child is not eligible for supportive housing services, not eligible for group homes. So preserving Medicaid eligibility for a person with disabilities is a very big deal. It's very, very important. And I'm going to talk about how you do that. So the big concern is, it might be easy to make sure that the person with disabilities doesn't have money in their name so that they can qualify for benefits. But if I'm a parent or a grandparent of this person that I love, I want to make sure that I'm leaving an inheritance for them, but I don't want that inheritance to cause them to lose their very valuable government benefits. So how do I do that? And we're going to talk about various things. The questions I'm thinking about as I think about planning for my loved one is this person going to be able to handle an inheritance? I may have somebody who maybe they can work, but they have a psychiatric illness, they have bipolar disorder. There are times when they're functional and independent, but there are times when they're overwhelmed and stressed and are unable. They may be subject to influence by other people. So they may or may not ever be on government benefits, but I don't want them to be in charge of the inheritance because I think it would be mismanaged. But maybe I have a beneficiary who is going to be on government benefits, and then I know I need to preserve the eligibility for those benefits. I may have concerns. How much is enough? Do I treat my 3 children equally when one of them has a severe disability? There are people who think the child with the disability may need less because they're going to be receiving a lot of government assistance. They're going to be in a group home, and maybe they don't need a full equal share, but maybe they need more. Right? Maybe this person with the disability, because they're not going to be able to work and they're not going to be able to be independent, they're going to need more than the others. So these are things that need to be contemplated and thought about. Who's going to manage the inheritance for the person with disabilities? And do I have enough? Another bullet point I didn't put in there is like, do I have enough? Like, maybe I need to start thinking about life insurance or other ways to create an additional fund of money to make sure that my person with disabilities is going to be well provided for. So let's assume we make a decision, we're leaving an inheritance for a person with disabilities. That person may or will be on government benefits. They can't manage money on their own. So we need to protect them, and we need to protect their eligibility for assistance. How do we do that? So the basic format is to create a supplemental needs trust. for this person with disabilities. This is basically a trust, like in many ways, like many other trusts that people create for an inheritance. People have been creating trusts and leaving assets to be managed by a third party for the benefit of their family members for many years. This is not a new vehicle, although it has some particular nuances. There's some special provisions relating to the administration of these trusts, which have been embedded in the law for about the last 30 years. Basically, it's a discretionary trust. The trustee will decide how the money is used and not the trust beneficiary. The basic purpose is to provide goods and services which are not provided by government benefits. If I'm a trustee and I give my trust beneficiary cash, they're going to lose government benefits. But I can maybe buy things for them so that their life is made richer than what they would get if they were on government benefits alone. So how will having a trust like this affect the person who's on government benefits? Well, the trust itself is not an asset. It doesn't count towards that $2,000 SSI limitation, $15,900 Medicaid limitation. It's as if though it's invisible. But the way that the trustee uses the money can create effects upon the person's government benefits. So if I am the trustee and I give cash to the person who's receiving benefits from the trust, that's income. And income will cause a dollar for dollar reduction in SSI benefits. Medicaid will also create a problem if someone is directly given cash. Now for SSI, if the trustee spends money on things that are considered food or shelter, then there can be a reduction in the SSI check. But the maximum reduction is 1/3 of the federal benefit payment. That's $264.67 is the maximum reduction. So if I were to pay rent for the person who is the trust beneficiary, instead of getting $881 a month, they're going to get $620 a month, roughly, right? That's okay. I know I'm going to get a reduction in the SSI check, but it's not a full reduction. So it may be advisable to use the trust in a way that causes a reduction, but not a total elimination of government assistance. And the trustee will have discretion to make that decision. Now, there are lots of different, for Medicaid, I forgot, I'm sorry, go back. For Medicaid, there's no reduction in benefits for in-kind contributions. So the trustee can pay for rent, can pay for housing. The only requirement is that the trustee not give the cash to the trust beneficiary, but that the trustee spend the money in a way that benefits the beneficiary. So this supplemental needs trust, where is it? How do you do it, right? Well, it can be a trust that's included in your will. Fran Pantaleo, as my last will and testament, leave everything to my husband if he survives me. But if my husband doesn't survive me, 50% to my son outright and 50% to my daughter who has a disability, but it's in a supplemental needs trust. It could be something that's included within your will, or, right, you can create that trust during your lifetime as a freestanding document. Now, I never do a testamentary supplemental needs trust. I don't like them to be included in a will. I'm not saying it's terrible. I'm not saying you should rush out and yell at your lawyer if you did one and insist on another one, but you should think about it. The reason I don't like a supplemental needs trust that's in a will is that the trustee has to get letters from the surrogate's court in order to act. And if you've created a supplemental needs trust for a loved one, that trust may be in existence for a very long time. And if the initial trustee that you appoint can't do the job anymore or dies, you have to go back to court to get another trustee. Anytime you have to go back to court, there can be a delay and a period of time when no one is able to act. And I want to make sure that my trust beneficiary always has someone who can act. And if I don't do the trust in a will, but I do it in a freestanding document, I can put succession provisions that do not require that we go back to court to get a new trustee appointed. Now, if you do a trust that you create during your lifetime, it can be a freestanding trust, the Robert Friedman Supplemental Needs Trust, right, in the name of the beneficiary, or it could be I'm doing a living will, a living trust, a revocable living trust. This is a document which can avoid probate. And I don't have a time to spend a lot of time on that, but it can be a will substitute. It says everything to my husband, but if my husband dies before me, 50% to my son and 50% in a trust for my daughter. So that trust is included within the revocable living trust, but it's not created today. That trust will only go into an existence when I pass away. So that's another option to think about. And if you meet with an attorney who does special needs planning, you can walk through the various different kinds of trusts that can be created. It's not a matter of one size fits all. Every supplemental needs trust can be a little bit different, and we can put different kinds of provisions in it. We can even toggle off whether something's a supplemental needs trust or a plain discretionary trust. I can have somebody who, if they're working and they're able to handle money, I can give them cash. The trustee can give them cash. But if at a later date they're not working and they're on government benefits, then it's administered as a supplemental needs trust. So these documents can be very flexible and tailored to the individual situation. So who should be the trustee? This is a big issue, right? This is something that people really have to ponder. Like, is it a good idea to name my non-disabled child as the trustee for my child with disabilities? Is that the person who knows them best, who's going to be in the best position to understand what they need? But can this person also manage money? Is this person going to be reliable? Are they around, right? Sometimes a family member is ideal. Sometimes a family member is not so ideal. If the person with disabilities has a psychiatric disorder or has always been a big drain on the family, and there can be a lot of mixed emotions and stress within a family if there's a person with severe disabilities, perhaps the family members are not the best choice. And maybe we should be looking towards a corporate trustee or a professional person. The problem with professional trustees, though, is they are going to charge a fee. And if there's enough money, that fee is well worth it often. But if the trust is smaller, there may be a reluctance to hire a professional trustee. The other issue is that there are a lot of the corporate trustees don't want to take a trust for a person with disabilities unless they think there's going to be at least $1 million or more. There are some, however, corporate trustees that will take a supplemental needs trust for less money, and there are some not-for-profit agencies which will administer a supplemental needs trust for a person with disabilities. So there are options, and that's something that, if you meet with your attorney, it can help you explore the various options before you make a decision. Now, let's say the one question I often get is, I think I would like a corporate trustee because I think it'll take off the pressure from my other children. But I'm worried about a corporate trustee. Maybe we're just, a face in the crowd to them. What if they're not really paying attention to my child's needs and they're not doing a good job? How do I get rid of them? After all, I'm not here anymore. And what if they're just making money off of my child, but they're not really doing a good job providing for them? So the solution to that is to name a trust protector, right? You can name your non-disabled children or other good family friends and family members to have the ability to remove the corporate trustee, ask for accounting, provide the trustee with guidance and advice. You can even put provisions that if someone is serving as a trust protector, they can be compensated for the time that they spend and their expenses in making sure that the trustees are doing a good job. And that's often a good compromise between family trustee and a corporate trustee is you kind of get the best of both worlds if you use a trust protector. Now, the biggest concern that everyone has if they have a loved one with disabilities and they've spent their entire life taking care of this person, right? How can anybody who's serving as a trustee, even if it's my child, know everything that I know? How do they know that my son, when he was 10 years old, was given a medication and had a horrible reaction to it. How would he know that he loves the Mets and hates the Yankees? That he loves football, but he absolutely can't stand dogs or is allergic to something. There's all kinds of things that you know about your child that no one else really knows. And you want to make sure that when these trustees, whether they're family members or corporate trustees, are actually in charge of making decisions for your loved one, that they have some information that you can pass on to them. And you can do that through something that we call a letter of intent. But it's not necessarily a letter. I mean, I have clients who actually do write an annual or every 2 years do write a letter in which they explain what life is like for their person with disabilities, what's changed, what's good, what's bad. And I have other people who do a binder. I love the binder idea because you can accumulate medical records and documents and reports and service plans in one place. And it's something that you don't just do once. You do it and you continually revise it. And it's not going to substitute for you. No one can substitute for you, right? But if you do this and you keep it updated, you're doing the best you can to pass on all your knowledge and all your expertise and all your love to the people who are going to carry on after you when you're not here anymore. So I don't draft it. I'm just a lawyer. You're going to do this if this is part of your planning process. I'm going to just talk briefly about self-settled supplemental needs trust. I've been talking about state planning for a person who's planning for their loved one with their assets. But if the person with disabilities comes into money, which would disqualify them from government benefits, and that person is under the age of 65, they can put their own money into a trust, a self-settled supplemental needs trust, which will not disqualify them from getting government benefits. They can pick their own trustee, but they can't be their own trustee. And then they can get very valuable government assistance and still keep the benefit from this money that they had, whether it was money they had because they used to work, whether it's money from a lawsuit or personal injury action, or somebody, God forbid, there was an inheritance and it wasn't left in a supplemental needs trust, and the person who receives that money is under the age of 65, they can put it into a self-settled supplemental needs trust. But the difference is this trust is going to have a payback provision to the government. So when the person who's the trust beneficiary dies, the Medicaid program will have the right to be paid back in full 100% for all services that were provided through the Medicaid program during the trust beneficiary's lifetime. So you want to avoid that payback provision if it's a trust you're creating with your inheritance. But if you're a person with disabilities, the good news is you can still have the benefit of that money, that inheritance, and still get all the needed government benefits that you're used to and that you need. There is another type of supplemental needs trust. I'm only going to mention it briefly because people may know about it. This is a pooled income trust for people who have too much income to qualify for Medicaid outright. Medicaid only allows people $884 of income per month. And if you have too much income, you might have to spend it down or pay it towards your Medicaid eligibility. There are not-for-profit trusts which can take this income and use it for your benefit without causing you to lose Medicaid eligibility. That's really all I'm going to say about that. Because this is a program being sponsored by Senior Services and Programs, I'm going to mention the fact that if you are an elderly person and you're worried that you may need Medicaid yourself, or even if you're not that elderly, you may know that there are transfer penalties if you give away your assets to your children and then qualify for Medicaid. However, if you have a child or a grandchild or even another loved one who is disabled, and that person's been certified as disabled by either the Social Security Administration or the Medicaid program, there's a special kind of trust that you can create and fund your assets to that doesn't cause any disqualification for your own Medicaid. And that's important to know for grandparents, perhaps. I've done those trusts a couple of times for people who are about to enter or had already entered a nursing home, and we were able to protect money for a grandchild and still get Medicaid immediately for the parent.
Hi, Fern. We had a question that
Mhm.
came in that's right in your line of explanation. So our participant asks, how would a supplemental needs trust for a certified disabled adult affect Medicaid benefits for their elderly parents?
So if I'm understanding the question is if a child has an elderly parent and wants to leave an inheritance for that parent, they can definitely leave an inheritance for the parent in a supplemental needs trust. And I've done that quite a number of times. I have children who are really providing a lot of financial support for an elderly parent who's running out of money. And they want to make sure that, God forbid, something happens to them, there's a sum of money which can supplement the care that their parent is receiving. Maybe they're in assisted living and the child has been paying for it. So yes, you can create a supplemental needs trust for your parent as part of your estate planning or as a document that you create and fund today. I hope that answers the question.
Terrific, thank you.
So I'm going to move on to talking a little bit about guardianship. So we planned for the inheritance for our loved one with disability, right? And now that person is either just the aging out of school services, turning 18, or is older, and we're concerned that they can't make good personal decisions, that they need assistance with making medical decisions, that they're not able to act appropriately in terms of caring for themselves. So what is the solution to that? Well, one of the solutions is to bring a guardianship proceeding. And there are two very different types of guardianship proceedings. For a person with an intellectual disability, a developmental disability, we used to use the mental retardation label. We don't use that anymore. But this type of guardianship was initially called a guardianship for person with mental retardation. It's now developmental disability. That is a guardianship which is commenced in Surrogates Court pursuant to the provisions of Article 17A of the Surrogates Court Procedure Act. It requires that the person have a severe intellectual disability. It includes people with learning disabilities, people with autism, and people with traumatic brain injuries. For everyone except a person with a traumatic brain injury, that disability has to manifest before the age of 22, right? And it has to be fairly severe. Doesn't mean that they went on disability benefits before the age of 22, but they have to have basically a disability that started at birth and it was obvious by the age of 22. Although there's no IQ language in the statute, as a rule of thumb, at least in Westchester County, then the court's looking to see that does this person have an IQ of under 70? Or if it's a little over 70, what is the actual functional capacity of the person? The court will ask questions like, is this person able to travel independently? Do they have a job? Can they make, handle money? Are they able to make their own medical decisions? There is a growing trend in the surrogates courts to be skeptical and to deny disability, deny guardianship for people who are higher functioning. And if you meet with a lawyer or you go to a service organization like ARC and you go to one of the programs that they do about this, they'll give you more detail about whether in your individual circumstance the person is going to qualify for 17A guardianship. In Westchester County, the judge is becoming a little bit more restrictive about who he will grant guardianship for. There have been more instances in which he has denied guardianship, where maybe in past years they would have sailed by. In New York County and Kings County, the judges are very skeptical, and they're denying a lot of these guardianships. So don't assume that just because your child has an IEP and a service plan, and you've been providing a lot of assistance to that person, that they're necessarily going to qualify for guardianship under 17A. The other guardianship is under Article 81 of the Mental Hygiene Law, and that's a guardianship that's processed in Supreme Court, and it's much more complicated and much more time consuming. So again, for the 17A guardianship, it's done as a simplified hearing in surrogates court. It's based on a petition by the person who wants to be guardian, and it's supported by an affidavit of either two affidavits by doctors, or one of the affidavits or affirmations can be by a New York State licensed psychologist. And it has to set forth specific information about the intellectual functioning of the person with disabilities. And you can ask for guardianship either of person or property or both. If you ask to be appointed as guardian of the property, you're going to have to do annual accountings. If the only money that the person with disabilities has is their Social Security or SSI check, then you don't really need guardianship of the property, because the Social Security Administration will allow that money to be administered by a representative payee, which isn't by a guardian, and you can avoid the annual accountings that would otherwise be required. If there is money and it's being managed by a guardian of the property, not only do you have to do an annual account, but you can only use that money but by making a petition to the court for permission. You have to hold the money jointly with the court, or you have to get bonded. So that would make the guardianship a little bit more complicated. In contrast, the Article 81 guardianship is full blown out litigation, right? It is not a sample form. There's a lot of very specific tailored information that has to be provided about the need for guardianship. The burden of proof is on the person who's seeking to have a guardian appointed. The child will have a lawyer appointed for them, either from Mental Hygiene Legal Services or a private attorney. In some instances, the court will appoint a court evaluator to investigate the allegations. And there is always a full-blown evidentiary hearing with testimony being adduced, and the burden on the person seeking guardianship is to prove, right, by clear and convincing evidence that the person will suffer, that either the person who's the subject of the proceeding or others will be harmed if the guardian is not appointed. And it could be financial harm, physical harm. You can't necessarily introduce medical records. If the person who's the subject of the proceeding objects, then medical records, psychiatric records cannot be introduced, right? So you have to prove your case based on functional evidence of functional incapacity. So it's a much more difficult standard, it's much more expensive. It can cost tens of thousands of dollars in legal fees to be successful in an Article 81 guardianship, whereas the legal fees will be a tenth of that in a 17A guardianship. And you may even be able, there are very easily available forms to file for a 17A guardianship on the Office of Court Administration website. And they're specifically designed to make it easy for people to do that guardianship proceeding without an attorney. Once a guardian is appointed, it may or may not be the people who petition for guardianship. Sometimes it'll be a third party if there's a lot of family disharmony. And the guardian will have to do annual accountings. So it's a much more complicated, much more full-blown process. It's also important to know that the powers that are given to the guardian will not include the ability to force a psychiatric hospitalization of the person with disabilities. And frankly, I frequently get consulted by people who want to bring a guardianship for their child or other loved one because they have alcoholism, drug addiction, or are not taking their psychiatric medications. And that alone is not going to be enough to have a guardian be appointed. And even if the guardian is appointed, they may not have the ability to force a psychiatric hospitalization. So what if you think your person that you care about doesn't quite fit within 17A, their IQ is higher than 70, they have a job, but they still need a lot of help with making medical decisions and handling their finances. It's not worth the time and expense, and you wouldn't be successful. There's no danger to them that would justify an Article 81 guardianship. Well, then you could think about having that person sign a power of attorney, which is a document which appoints someone to handle finances, make financial decisions, tax returns, apply for government benefits. Power of attorney can be revoked, but if your loved one trusts you, then maybe that's and is willing to accept assistance from family members, maybe having them sign a power of attorney is the answer. Healthcare proxy is a document which appoints somebody to make medical decisions for you, and it can be supplemented by a medical records release or HIPAA authorization, for example, which would allow family members to go to the doctor with the person with disabilities and assist them with understanding what the doctor is saying. A living will may or may not be appropriate. It's a statement about what your wishes about end of life care. I find that sometimes a person with an intellectual disability is a little overwhelmed by that form. You don't have to have a living will. The agent under the healthcare proxy will have this ability anyway. And there's increasingly a movement for supported decision-making for people with disabilities. So instead of depriving them of all of their independence and rights to make decisions on their own, having that person with disabilities self-appoint the people within their circle who they want to be involved and consulted when that major decisions have to be made. And there's some pilot programs that are being run by many of the developmental disability services organizations such as NYSARC, which are really working on developing protocols and formal ways, short of guardianship, for family members to be brought into the process of assisting a person with developmental disabilities running their life and making decisions. So that's all I have to say about guardianship, unless there's any specific questions about that. So I just want to talk very briefly, because if we have enough time, about ABLE accounts, because you may have heard about these ABLE accounts and may be wondering, does my child or grandchild with a disability need one? And what are they? So ABLE accounts stand for Achieving a Better Life Experience Act of 2014. And it enables, it's basically like a 529 account which are used for tuition, and they're actually under the Internal Revenue Code in Section 529. And these are accounts which can be set up for people with disabilities in which they can save for qualified disability expenses without jeopardizing their eligibility for SSI or Medicaid. New York has a program since 2017. It took us a couple of years to get the program up and running. I gave the phone number that you can use to set up an account and the website, www.mynewyorkable.org, where you can get more information about these accounts. So these accounts, a person with disabilities has to establish disability before the age of 26, either because they've been approved for disability benefits, or there's forms that can be set up to establish the nature of their disability. You can only have one account per individual. It can only be funded with a maximum of $15,000 per year, and the account cannot go over $100,000 if the person is on SSI. There's a maximum of $500,000 if the person is not on SSI. And the money can be invested in various ways. There, if you go on the website, you'll see conservative portfolios, more aggressive portfolios, CDs, once the money is in the account, the earnings are tax deferred and tax free upon being withdrawn if they are used for qualified disability expenses, which I'll talk about. And you can set up the account so that it links with either a checking account, or you can actually get a debit card that can be used for the person who has the account. Qualified disability expenses include education, health, housing, transportation, assistive technology, employment, funeral and burial. It's a very long list of things that it can be used for. But you have to be careful that you only use the account for these things. If you use the account for something outside of the permissible expenses, there can be severe penalties for doing that. Now, it's not a substitute for a third-party supplemental needs trust. right? It can be a substitute for that sole benefit trust if the person who is establishing it only has a little bit of money. So if somebody was named a beneficiary of a life insurance policy and they get $5,000, you don't want to necessarily go through all the hassle and pay legal fees to create a self-settled supplemental needs trust. That person with disabilities can put the money in an ABLE account and they can manage it themselves as opposed to having a trustee manage it for them. And then as long as they use it for qualified disability benefits, they didn't lose their Medicaid or SSI. However, right, at the death of the person who created the ABLE account, there's that payback to the Medicaid program. So it's not a way to leave an inheritance for a person with disabilities. And you could only use it for qualified disability expenses, not for the longer list of things you could use a regular supplemental needs trust for. There's a limitation on how much can go into the account. And this is a substantial issue. If you're the person who's the ABLE account is going to be funded for has a guardian, the guardian cannot take that person's money and put it into an ABLE account. And the ABLE account has to be established by the person with disabilities. And you have to get an order from the surrogates court if you're the guardian to take the person with disabilities money and put it into an ABLE account. If you don't have that ability in your guardianship order, you would have to go to court to do so. And that's cumbersome, right? So that's basically it in terms of what I was planning to discuss. I'm going to see if I can figure out how to stop sharing. Great, I did. And I'm happy to take any questions that anybody may have.
Sure, thank you, Fred. And we have a lot of terrific questions that have come in for you. So I'm going to start with the first question that had come in towards the beginning of the program. And our question asker wants to know that there's a child under the age of 21 that has an intellectual disability and is an American citizen, but is living in the country of Greece. Can they get benefits?
No, you can only get benefits in the US if you are a resident here. So you're not, oh, maybe you're talking about the disabled adult child benefit. So if the parent is living in the US, but has a child under the age of 21, you know what? I think it's too specific a question, and it's really not a generic question. It's a very specific question. They would need to have a lot more individual information for, and that's beyond the scope of this program, unfortunately.
Perfect. So question asker, if you have a very detailed question, you can put it into seniorlawday.info into the Ask Us button, and we'll be happy to try to address your question there. The next question is, if I'm a 17A guardian for my son with intellectual disability, do I need a power of attorney, healthcare proxy, or living will?
Everyone needs a power of attorney, healthcare proxy, and living will. An essential part of every single estate plan should be not only who's going to inherit my stuff when I'm gone, but God forbid I get sick, who's going to be able to manage my money for me and the people who are dependent upon me. So whether if you have a child with a disability and you're the person who provides all the extra things that the government is not providing for your child, you want to make sure that, God forbid you get sick and you're in the hospital and you can't, write checks, that you've got somebody who can manage your finances so that they can continue to support your loved ones. So everybody, it's part of an essential estate plan. I know it's a senior law day collaborative mantra is everyone needs advanced directives. Now, if your child who is the subject of your 17A proceeding, you have a child and you're guardian of the person and property for them, then you should not be asking your child to sign power of attorney and healthcare proxy because your guardianship papers give you that authority. So that's a separate question.
Thank you, Fran. And our next participant asks, at what point do you set up a guardianship for 17A?
That's a very good question. So the You are permitted to file a petition for appointment of a guardian under 17A within 6 months of the child's turning 18. The court will accept your paper as much as 6 months before the child is 18. You don't need guardianship before the child is 18 because while they're a minor, as a parent, you have the ability to make decisions. Now, I have clients who call me in a panic. My child is turning 18 tomorrow and I have to be appointed as guardian. Well, there's no thunderbolt which is going to suddenly hit and prevent you from being involved in your child's life on the day they turn 18 if you are not their guardian. And in the school context, the child will often be asked, do you still want your mom at your IEP meeting? Is she still involved with you? And the answer is fine. Now, we would highly recommend that if you're going to be bringing the guardianship, you try to bring it as close as possible to the child's 18th birthday, but I don't want people to panic and think that, oh my God, all of a sudden I'm going to be stripped of all authority. My child's in the ER, they're not going to listen to me. That's not going to happen. But you do want to bring it as soon as possible. The one, if you have a child who you're worried is going to drop out of school and might refuse to continue with an educational placement, then it's particularly important, especially if the child's in a residential placement and you want to be able to keep them there, that you bring the guardianship as soon as possible. I've had clients who never brought guardianship proceedings, and now they're in their 60s or 70s, and the child is in their 40s and 50s, and they're realizing, oh, if something happens to me, we need to make sure that a guardian is appointed. So it's a good idea to start as early as possible, but don't think that you're in the middle of a burning building, and if you don't get it done, something terrible will necessarily happen.
Thank you, Fran. And the same participant asks, how do you bring the guardianship and where?
So the 17A guardianship proceeding is a petition that's filed in the Surrogates Court of the county where the child is living. If the child is in a residential facility, but it's for educational purposes, that's not considered their residence. So you would still use the parent's county of residence in most cases. It is commenced by the filing of a petition that is supported by affidavits by at least one doctor or two doctors, and it's either two doctors or one physician and one New York State licensed psychologist. The do-it-yourself forms are available on the website of the Office of Court Administration. You Google New York State Office of Court Administration guardianship forms, and the website will come up. I did it last night to make sure, and it comes up right away. And the forms are fairly self-explanatory, and they include a checklist that the Surrogates Court has provided where you can go through and say, did I answer all the questions properly? What do I need? In addition to the petition, you need to submit to the court a certified birth certificate, which will be returned to you if you request it. Some counties require fingerprinting, not Westchester, but the Bronx, for example, does. And they may require, even Westchester will require a fingerprint if it's a person who's seeking guardianship is not the parent. There's also a address form where you have to list your addresses for everyone who lives in your house for the last 26 years, so 27 years. And that goes to the Office of Child Abuse just to make sure that the person who's seeking to be appointed as guardian was never found to be responsible for child abuse or neglect. And basically, if you submit all those forms to the Surrogates Court, you would go down and file them yourself. A hearing date will be sent. The person who's the subject of the guardianship proceeding has to be served. A guardian ad litem will be appointed for that person to make sure that there's no concerns or any reasons why a guardian should not be appointed. And sometimes the hearing is held nowadays in Westchester, they're doing hearings just like this on Zoom, right? And just a few questions being asked by the surrogate, and then you get your guardianship papers. In some instances, depending on circumstances, it may be a little more complicated. There are lawyers who do this and who help because some people are good with paperwork and some people are not. And some people feel that they're good with paperwork and they can handle it on your own. It's a very individual decision.
And who can file for guardianship other than the parents if the disabled adult child is a US citizen, but the parents are undocumented?
The mere fact that the parents are undocumented does not mean that they can't be appointed as guardians. So, well, but they may have a problem. Actually, I have to double check that. Generally speaking, a guardian does have to be a citizen. So there is a priority of people. Siblings have a priority, parents, immediate family members have priorities, but even anyone who has a concern for the welfare of the person with disabilities can petition. I have a case right now where there's a gentleman who's in his 40s who's in a group home in Rockland County, and his mother recently passed away. She lived in Baltimore, and she set up a supplemental needs trust so that the inheritance for this gentleman is taken care of. But the group home has asked that someone be appointed as guardian. By the way, siblings and parents who have a loved one in a group home will be involved in that person's life and have to be consulted under New York State laws and regulations, even if they're not the guardian. But once you start getting to more distant family members, the group home just felt more comfortable if they had a guardianship appointment. And so there is a cousin who lives in the Midwest, but who is very involved with this person and, speaks all the time to the people in the facility. And she is going to be petitioning to be the guardian, even though she doesn't live in New York and she's a second cousin, but she's the person who has the most interest in him. And but she should not have any problems to be appointed. It can even be a non-family member, but you may have to locate immediate family members because they have to be served with notice that the proceeding is being brought.
Great. So we have an ABLE account question.
Okay.
Can an Article 81 guardian go to the court and get permission to open an ABLE account?
Yes. Yes. Either a guardian under 17A or 81 can get permission to open an ABLE account. They will probably still have to account to the court for how they use the money, but because an ABLE account has to be opened in the name of the person with disabilities, which could be by their guardian, but you probably would need permission in order to open it.
Great. And can you have an ABLE account with $500,000 in assets plus assets in a supplemental needs trust?
Yes. So you can have both. And the ABLE accounts, I don't know why you would want to have $500,000 in an ABLE account. To me, you're far better off probably with a third-party supplemental needs trust. But maybe if the person had money and you can have up to the maximum in an ABLE account. Person won't get SSI with a $500,000 ABLE account, and there'll be a payback to the government from that ABLE account. And then there could also be a third-party supplemental needs trust, which may say, for example, if my child with disabilities passes away, my other children get what's left in that account when that person dies. You can have both. The one advantage of an ABLE account that's fairly significant is that there can be some additional government benefits that are available for a person whose expenses are being paid out of an ABLE account. And there's been some talk about whether this will change, but I think it's still in effect. That I mentioned before that if I'm on SSI and someone pays for my food and my shelter, I get a haircut, I get a reduction in the amount of my SSI check. However, if an ABLE account is paying for housing expenses, that doesn't affect SSI. So when I'm drafting a third-party supplemental needs trust for a client that I know that person is disabled, I specifically state that the trustee can give money to an ABLE account for the person who's disabled because that may enhance their government benefits, right? So I can give it to the ABLE account that pays for their rent, and then the person's SSI check is not reduced.
Terrific. Fran, so for those individuals with younger children who have 529 accounts in the parent's name, the child's the beneficiary, can you keep it going for potential use for an eligible transition program after high school? And then the second part is, if the child doesn't go to an eligible transition program, can the 529 be transitioned to an ABLE account without interfering with Medicaid eligibility?
So that's a really good question. So, oftentimes people start putting money into, grandma puts money in a 529, mom and dad put money in a 529 because we're expecting our child is going to go to college. And lo and behold, that's not in the cards. And person may be going to a vocational program, a life skills program. If there are lots of things that the 529 can pay for beyond college. And the 529 account is not an asset of the person with disabilities. So it doesn't affect their SSI or Medicaid eligibility because it's an asset of the person who's the custodian for purposes of government benefits eligibility. And the money in the 529 account specifically can go into an ABLE account under the ABLE rules, provided that the person, the ABLE account is established properly. So the person who's with disabilities is able to open up an account, or there's a court order which allows it for a guardian. The money can be transitioned from the 529 educational account to the ABLE account. It can also, a lot of people don't realize, I can open up I have a grandchild now. So my grandchild was born on Christmas Day, and I have great, hopes and dreams for him, as everyone does, and I hope he goes to college someday. And I plan this year to start putting money into a 529 account for him. So if it turns out that college is not in the cards for him, and I have another grandchild, right, I can put the money in the other child's 529 account. I can change who the beneficiary is, or I can continue to use it for myself if I want. I want to learn how to speak Italian. I'm going to go to college. And when I retire, I'm going to take Italian lessons. I can use that 529 for myself. So they're very flexible vehicles. And yes, they can be moved into an ABLE account.
Terrific. So switching gears a little bit, our participant is retiring and their husband is retired. The participant plans to take Social Security in 3 years. They have a son who has autism but works. Does he qualify for some of my Social Security benefit because he was diagnosed before 22?
Maybe, right? Very good question. And the answer is maybe. And this is a reason why I frequently advise my clients that have a child with disability, right, and that they should consider applying for SSI at 18 while they're still in school, while they have IEPs that talk about all the child's deficits. We hope for the best for our kids. We plan for the worst. It's easier sometimes to qualify for SSI when a person has all those educational evaluations easily available and they're still getting a lot of supports. And if they get SSI and then we know that they were certified as disabled before the age of 22, they may be able to later get that Social Security disabled adult child benefit. It can be much harder to prove that the disability, and by the way, it's disability according to the rules of the Social Security Administration. And they define disability as inability to work. So if your child has autism, but they worked for 10 or 15 years, then it's going to be very difficult for them to prove that they're disabled when you retire and they're 40, right? So I can't give a conclusive answer, and a lot will depend on the specific nature of the disability. Autism, as we know, is a spectrum disorder, right? Some people have severe autism. They're nonverbal. They can't communicate well. They'll never be able to work and be independent. Some people with autism, especially after receiving marvelous services from the school system, end up with jobs and self-sufficient. So you can't go on the diagnosis with autism alone as something that will be sufficient to enable the child to receive disability benefits based on your work history.
If the participant moves out of state and their disabled adult stays in New York, will that impact a special needs trust created in New York? So
No,
it appears the trustee's moving out of state.
no, the trustee doesn't have to be in New York. Neither does the person who creates the trust. I always recommend, if I'm creating a trust for a person, a supplemental needs trust, and the beneficiary is in New York, I know the bells and whistles and the language that I like to include in my New York trust. If I have a client who lives in New York, but their child with disabilities is in another state, I may be consulting with a lawyer from that state to make sure that I didn't put any language in my supplemental needs trust that causes a problem with eligibility for benefits in the other state. I have a client right now who's a guardianship was brought in New York. The family member moved to Arizona. It's still a New York guardianship. The child then came into money from a lawsuit, and we had to create the supplemental needs trust to be valid both in New York and Arizona. So, you know, we coordinated that. But the trustee can move, and I always put language in my trust that we can change the jurisdiction of the trust to a different state. And if I also give the trustee the ability to amend the trust if the beneficiary moves to another state and there's some kind of language in the trust that they don't like, we give the trustee the ability to modify that language.
Terrific. We have a question where a guardian wants to open an ABLE account for their son in another state to avoid surrogate's court approval. Is that permitted?
No, absolutely not. If you are a New York guardian, you have to follow the rules that apply to a New York guardian.
Does my 17A guardianship of my son preclude the need for my son to have a healthcare proxy power of attorney living well?
Yes. And I mentioned that previously. If you are a guardian under 17A, you have very broad powers, right? If you're a guardian of the property, it's full financial decision making. If it's personal decision making, it's full personal decision making. And your guardianship order will specify that this includes medical decision making, including end of life care in most instances, if you generally would have checked that off. So your child doesn't need, and in fact, it's inconsistent with your petition to the court saying that my child is incapacitated, to ask them to then sign a document which appoints you to do things. If you have full guardianship of person and property, the child does not need and should not be asked to sign a power of attorney, healthcare proxy, living will, or anything else.
Okay, great. So I know we focused a lot on benefits for close family members, but our participant asks, there are a lot of single individuals out there who have no relatives to care for them. What sort of services are available if there's no immediate family in the picture?
That's a really good question. And it's a tough question. So if the person with disabilities is able to basically manage for themselves, and they needed, but they come into money, there are, you can create a self-settled supplemental needs trust and appoint someone you know to manage it. But there are not-for-profit agencies which will manage a supplemental needs trust for a person with disabilities. I have a client today whose mother died and named her the beneficiary of an annuity. It's about $140,000. You know, it's not enough for her to go off benefits because her benefits are really important to her. She has Medicaid services, and she doesn't want to lose that. But the $140,000 is nice, and she wants to be able to use it. So we found a not-for-profit agency she gave the money to, and then she will go to that agency and ask them to pay for things that she needs. What would she do if she didn't have capacity to even do this? You know, what if, you know, a person with disabilities has a parent who's always been managing for them, right? And now they pass away and there's nobody who's willing to step up to the plate and manage for this person. There are some organizations, there's not a lot of them, but there are some organizations that step in that circumstance. There's a particular organization in New York City called Disabled and Alone. It's a not-for-profit agency, and we're actually working with them now. Our client is a gentleman with a traumatic brain injury who's in his late 40s. He's able to live independently, but probably not going to be able to manage all of his finances. And we're hoping to contract with this agency to provide assistance to him. But it can be that's a difficult situation, and sometimes guardianship ends up being brought, and an agency is appointed as the guardian because there are no family members who are willing and able to step in.
So we have 2 more questions, and I know we're getting a little tight on time. So
Okay.
our participant asks, can I transfer a guardianship to another state?
Yes, there is actually a law that governs the transfer of a guardianship to another state. So, and that the provisions have to be very strictly followed. The receiving state, let's say a person has a New York guardian, my clients who moved to Arizona, right, are in the process of deciding whether or not to do that, because they may come back to New York, but currently their guardianship is in New York. The fact that they are in Arizona does not invalidate that guardianship. They're still guardians, and they account to the New York court. But if they wanted to transfer the guardianship to Arizona, they could do that. They would need to file a proceeding in Arizona. They have to get an order from New York agreeing to transfer, and then the guardianship gets transferred over. It can be done.
And we
and you don't have to, you don't have to like reprove everything, but you may still have to have some evidence and some testimony about the need for the guardianship, but it shouldn't be as complicated as the first proceeding.
When I get Medicare at 65, will my disabled adult child and ward, I'm the guardian, who has SSI and Medicaid, can they also get Medicare as my dependent?
So when I turn 65, I can get Medicare, but if I'm not also receiving Social Security retirement benefits, my child is not going to get anything because I went on Medicare, right? If, however, I retire and I start to receive Social Security retirement benefits, or I die, or I receive Social Security disability benefits, then my child who turned 22, who became disabled before the age of 22, will get a Social Security disabled adult child benefit based on my work history. And 24 months after they start to receive that check, they will get Medicare. So it's not right away, but 24 months later, they get Medicare. They get it automatically. The card comes in the mail. Wow, what's this? They can still have Medicaid, and Medicaid provides many services that Medicare does not. But now they'll have the ability to see doctors that didn't take Medicaid. So, it is good because it often provides, additional health benefits for the person with disability.
Fran, thank you. This was a terrific program, and thank you to everyone who's put some incredibly kind comments for Fran in the chat. If you have questions after the program, you can reach out to Fran directly. She's a partner with Bleakley, Platt, and Schmidt in White Plains, or you can visit us on our website, which is seniorlawday.info, and click on the Ask Us button, and you can submit a question and we will get back to you to answer your question or connect you with the right professional who would be able to get you started on your learning journey. So thank you, everyone.
Sarah and Bruce, I have, okay.
So there, Bruce is showing everyone where our Ask Us button is. So if you click on it, a field will pop up where you can put in your name and your email address and type your question, and we will get back to you.
Sarah and Bruce, I have some additional outlines that cover some of the things we talked about. I should have asked this question before, but if I email those, Would those be available as handouts that are connected to this webinar?
We would be happy to post any materials that you're willing to share with us right underneath the video once it goes live in a couple days. So thank you.
Perfect. I'll be happy to do that.
And we hope that everyone's answer to take action, especially to put advanced directives in place, if you do not have them, is very likely.
Well, it's been my pleasure to participate, and thank you for asking me to share my knowledge with everyone. It's been a pleasure.
Okay, well, thanks so very much now, everyone, and we will end the webinar now. Have a great day.